wheelchairs on the highway. You cannot see that individual there. Valdosta must do something about this. Look at that. Look at that. No rear end reflectors or nothing. This is in Valdosta, Georgia.
Why are you all out here today?
We are the soldiers of Christ, and we have the right to vote. And it's wrong for others to take our right to vote, because it's very important. It's our constitutional rights.
Will y'all repeat that again for me, please?
We are the soldiers of Christ, and we have the right to vote. And it's wrong for others to take our right to vote, because it's very important. And it's our constitutional right.
Have mercy. Let's go and ask them, why are you all out here today?
We are the soldiers of Christ, and we have the right to vote. And it's wrong for others to take our right to vote, because it's very important. It's our constitutional rights.
Will y'all repeat that again for me, please?
We are the soldiers of Christ, and we have the right to vote. And it's wrong for others to take our right to vote, because it's very important. And it's our constitutional right.
Have mercy.
The first one is 2012 number 31, which is Telfair County number 38, my binder.
Yes, sir. This case had three major areas of complaints. The first complaint regarded allegations of absentee ballot mishandling and fraud. The second centered around problems at the Lumber City precinct on election day. And the third was something that our investigators discovered during the process of the investigation, and it had to do with administrative errors and failures with election documentation. Regarding allegations that absentee ballots were being improperly handled, processed, and illegally assisted, we had cross complaints. We had several different sides alleging that absentee ballots were being improperly handled. We were unable to determine that there was any large conspiracy, that there was any type of organization that was involved. We interviewed approximately 50 individuals regarding absentee ballots. We did come across several cases where individuals either illegally assisted people with absentee ballots and or illegally failed to document assistance, and several cases where people illegally possessed absentee ballots once they had been voted. We had gotten reports from people that absentee ballots had showed up in bundles at the post office. However, there was no indication of who may have handled those ballots and collected those ballots. So as far as the general allegation that absentee ballots were being improperly handled, while there's some indication that there may have been something going on, with all the investigation we did, we were unable to determine if it was a concerted effort. We ended up interviewing 33 absentee ballot electors in terms of trying to see if there was any connection, And what we found was there were 13 instances of those 33 of illegal activity. We found out that the following people illegally possessed absentee ballots, and those people were Beulah Dollar, Linda Clemens, Patsy Vaughn, and Alice Strong. We found that several people either illegally assisted or failed to sign as assisting when completing an absentee ballot, and those were Inez Carnes, Linda Clemens, Beulah Dollar, Alice Strong, and Martha Williams. As far as allegations with the Lumber City Precinct, our office received several complaints from people about the Lumber City Precinct. Interestingly, we didn't, as far as I can tell, we didn't receive many complaints from individuals who actually experienced the problems, but we got a lot of sort of general complaints about what happened in Lumber City Precinct. And most of them involved people who had requested absentee ballots who were attempting to vote on Election Day. And we interviewed 4 out of the 5 poll workers, and what we found was that when people had either requested an absentee ballot and had not returned it, they came into the polls and wanted to vote on Election Day. They, of course, were told they had an absentee ballot outstanding and that they had to cancel that. And the people at the poll office reported that they had difficulty getting in touch with the registrar's office to verify that somebody still had an outstanding absentee ballot. So that caused some delay, and I think that contributed to the report that people were not being allowed to vote, because, of course, if you show up to vote at the polls with an outstanding absentee ballot, you should be stopped from voting until they can clarify whether or not your ballot is still outstanding, and you cancel it. But as the board knows, there is certainly a procedure for doing that. All the voters were allowed to vote provisional ballots if necessary. There were reports that people came in wearing shirts that had candidates' name on them. In every case, those people were intercepted and were told to turn their shirt inside out or go out or fix it. And in every case, we followed up on the people complied with that. At one point, there were some contraband flyers found near the front of the polling place at Lumber City. As soon as that was identified by the election officials, that was confiscated and destroyed. There was no indication as to who put that campaign literature there, but that would certainly be in violation of the law. And again, the complaints, we didn't receive a lot of specific complaints from specific individuals. As far as the administrative errors, when we started to examine these absentee ballots to attempt to detect any fraud, we also found there were problems with voter certificates, of course, which people fill out when they vote in person. And we found that there were 2 voter certificates that were accepted without a voter's signature, 13 that were accepted without the voter's date of birth, 14 accepted without the poll worker's signature, 33 accepted that indicated there was some assistance but didn't provide a reason for assistance. There were 49 certificates that were accepted without the elector's address. There were 51 certificates that were accepted with no indication that the voter's ID was checked or what form was presented. There was one case where a voter named Fred Hamons III went in to vote. He was not registered to vote. However, when he filled out his application, the poll worker pulled up his grandfather, who was registered to vote, who was Fred Hamons I, and they allowed Mr. Hamons III to vote in the place of his grandfather when he wasn't registered to vote. I think it was an error on the poll worker. He or she saw the same name and allowed Mr. Hamons to vote when he was not registered. We do have in the citations, we have a Michael Allen cited for failing to correct a voter's ballot. In this case, there was a voter who went to vote, and she contacted the poll worker and said, "I'm not sure if I have the right ballot because I think I might have this candidate and I should have that candidate." Michael Allen told her, you may not know what district you're in. You may have the right ballot. You may not. She went and voted. Initially, we had him cited for a violation of not correcting her ballot. Upon further review and going through the case, I don't know that there's evidence to sustain that. He did not tell her, you have to vote that ballot. I think the voter equivocated as to whether or not she had the right ballot or not. So I don't think there's a charge to sustain on Michael Allen. I would recommend that specific violation be dismissed. To bring it all to a close, for the respondents, I would recommend that the Telfair County Board of Registrars, the election superintendent, Rebecca Widener, Betsy Johnson, and Linda Cartwright all be bound over to the AG's office on the citations that are listed in the report. I recommend that Fred Hamons III, Alice Strong, Beulah Dollar, Patsy Vaughn, Linda Clemens also be bound over to AG's office on their listed violations. And then for Inez Carnes and Martha Williams, these are women who assisted their disabled husbands in voting their absentee ballot. They did not sign as assisting. There's no indication that there was anything nefarious or malicious in doing that, and I recommend that they receive letters of instruction reminding them about the proper necessity to document assistance with an absentee ballot.
All right, any questions for Mr. Harvey? Mr. Word?
I have a question, Mr. Harvey. The 162 counts about improperly completed voter certificates, do those relate to more than one precinct?
Yes, those were more than one. That was the total that we looked at.
Anything else, Mr. Harvey?
No, sir.
Anyone else wishing to speak? Yes, ma'am.
Good morning,
Good morning.
Mr. Secretary, Election Board members. My name is Tony Sawyer. I am the county attorney for Telfair County. My address is 311 West Central Avenue, Fitchfield, Georgia, 31750. And I'm here to speak on behalf of Telfair County Board of Elections, the current Telfair County election superintendent, as well as Ms. Cartwright, the former Telfair County election superintendent, which is also a probate judge. Ms. Johnson is actually here today, and she's represented by her own personal attorney. I did provide a response to Mr. Harvey, and we communicated by email. And if I may, I'd like to address Ms. Linda Cartwright first. The allegation that she allowed Mr. Hankins to vote, to cast his ballot. Ms. Cartwright was not the individual that actually was up front that assisted Mr. Hankins. There was another individual, another poll worker. And what occurred is that there were actually 3 individuals named Fred Hankins that were registered to vote for that particular precinct that lived in the same household. There was a Fred Hankins Sr., a Fred Hankins Jr., and a Fred Hankins III. When this individual came in to vote, he gave the name Fred Hankins and provided his ID. The gentleman that assisted him did in fact look at the ID, but he did not check the date. We do not in any way deny that that occurred. And from that point, Fred Hammond III was, for whatever reason, allowed to vote under Fred Hammond Sr., and we do apologize for that. So we just wanted to make it clear that it was not Ms. Cartwright, so we would ask that the charge against her be dismissed. She was poll manager, but she was not aware of what was going on. If I move forward with, we just move forward with the Telfair County Board of Registrars with regard to the issues with the absentee ballot applications, as well as issues with absentee ballots. The only thing that we can say is that we sincerely apologize that this occurred. At the time of this July 2012 primary, we had a completely new staff. The chief registrar had just been hired in December. She had not received any type of training other than 2-week training in-house with the prior registrar. She had not had the opportunity to attend any type of B-RAG training or any other type of training that was offered. So at that time, staff just really honestly did not know. What we can say now is, as far as training, Chief Registrar has been trained with B-RAG. She's been trained in 2012, 2013, 2014. She's coming up for the 2015 training. She does the ElectioNet training. She now does the mandatory continuing education for the registrars, which I think is 12 hours. Her new assistant is also signed up to attend 2 sessions of B-RAG training this year. Now, when there's an issue with the application ballot, we send out letters informing the voter that there's an issue with the ballot application, absentee ballot application, explaining to them what the issue is. We send them a new absentee ballot and ask them to complete it. If we get a ballot and there's problems with the the ballot, we send them a letter explaining why the ballot was rejected. And then we will tell them their options that either, if time permits, they can come and vote in-house absentee or vote at the polls. We have worked on that. And it's my understanding that I was not the county attorney in 2012. Mr. Marchant, who's representing Ms. Johnson, was actually the county attorney at that time. But since I've been a appointed county attorney, I don't think there's been any other complaints as far as registrar's office that I'm aware of. The issue with the election superintendent's office, which is also the probate judge, again, all we can say is that, these errors occurred and we apologize. We have new poll workers. These poll workers now are being trained 4 to 5 hours per each election. And in addition to that, the poll workers are individually trained on their individual duties at the poll. So if somebody is to be up front and working on the voter certificates, they are shown individually, this needs to be completed, this needs to be completed. Of course, they have to complete the electioneering training. So we are working on making sure that what occurred does not occur again. And again, as far as I'm aware, there have been no further complaints with regard to the elections superintendent's office for any elections after the 2012 primary. All right.
All right, well, thank you for being here, Ms. Sawyer. Any questions for Counselor? Okay, thank you.
Secretary, just for the record, I'll submit what Ms. Sawyer sent to me for the board's consideration. Also, I have an email from Michael Allen, who's the person that I've suggested be dismissed. Explain his position.
Thank you.
Thank you. All right.
Mr. Chairman, my name is Joseph Marchant. My address is 303 Main Street, P.O. Box 4218 is my mailing, Easton, Georgia 31023. I'm here only on behalf of Miss Betty Johnson, who was the probate judge and election superintendent at the time of this election. She has since retired, and just a little background on Ms. Johnson. She has served our county as a public servant for over 30 years. She served 2 terms as clerk of Superior Court. Our county has the 2-term tenure act, which is something that's kind of rare in Georgia. I don't think there's very many that have that. So she, if it had not been for that, she would have continued probably in the clerk's office. But at some point, she made a transition into the probate court. She actually served as a clerk there in the probate court for 8 years, but during that time period, she didn't really handle elections. Wasn't really involved in that. When the probate judge, who's actually now the current probate judge, previously served 2 terms, and Ms. Johnson ran for office and was elected. And this was also one of the first elections that she held, certainly a large-scale election. Essentially, we don't disagree with anything that Mr. Harvey said with regards to the 2 issues that affect Ms. Johnson. The only 2 issues that really affect Ms. Johnson's office is the discrepancies in the voter certificate cards and some information that was missing from those. We went through and looked at those ourselves, and we would agree that it was that type of information, various things that was missing from those cards. Obviously, the poll workers looked over that. She's not going to actually examine 3,500 cards, but it is her responsibility as the election superintendent. I think as has been previously discussed, it appears that those things are being corrected and have been corrected through the current election officials. The other issue is this issue with Mr. Haynes. This is an issue that could have happened anywhere. Had something very similar almost happen in my office this week. There were 3 Mr. Hayneses. The first, the older 2 died and left the grandson. The grandson was actually inherited the house of the grandfather. And so he moves his house, so he's getting his mail there. And he also gets a voter registration card. It's his grandfather's card apparently, but he believes that it's his. And that's why he went to vote. And a matter of a third versus senior or not checking the date of birth. There's there's no criminal intent with any of this stuff. Certainly do admit that a mistake occurred. Ms. Johnson has since retired. She has no plans to return to public office that I know of. We would ask that the case be resolved with a letter of instruction and not be referred to the AG's office as it relates to Ms. Johnson only. Thank you.
Okay, any questions, Mr. Marshall? Thank you. Anyone else? Yes, ma'am.
I am $0, and my address is 58 East Grant Street, Post Office Box 75, Lake Ridge, Georgia 31055. And I have been cited for having possession of absentee ballot. The persons that were mentioned were Yvonne Stustier, who is blind, Randolph Freeman, from a stroke and has paralysis in his hand, Braden Hamilton is blind, and Johnny Fuller. Okay, I assisted these persons. I also signed these absentee ballots that I assisted them. Yvonne Stustier is always making an attempt to write her name. I have her finger, a piece of paper, and put it on the line. And then she signed and up and down. But I signed my name that I assisted her, and I wrote on there the reason that because of blindness. And so when the investigator came, she said that they had her to write her name. She said she wrote it and like she write it whenever she was doing her absentee ballot. I assisted her because she could not see how to mark the candidates. And I signed my name that I assisted her, and each time. On Grady Hamilton, the same thing transpired. He said that he could sign his name, but he could not make the choice of the candidates because of blindness. He signed his name, but I signed my name that I assisted him. And then on Randolph Freeman, this is something like a relative, because my son has been with his sister 37 years. He had a stroke, and I'm almost like his caretaker. I go to visit him several times a week. He had someone has to place him in the bed at night and help him in the morning. I take meals to him, and then on Sunday, along with 12 other people, I pick him and take to him. But he has paralysis in his hand, and he cannot write, he cannot even understand his handwriting. When I registered him to vote, I signed that I registered him because he couldn't understand his handwriting. So I filled in his candidate. He told me who he wanted to vote for. I filled in his candidate. Then I assigned my name that I assisted him. He moved from one apartment to another. I had to do a registration form because of change the address. I signed my name that I assisted him with that because he had a stroke and he could not write. On Johnny Fuller, he lived next door to Arthur Randolph. And Johnny Fuller, he asked me to watch him to see if he was filling the back of his absentee ballot out correctly. He said he had filled out one time before and they threw it out, said it wasn't complete. I did not put my hand on his ballot. The other three, I had to put my hand on them because I had to do the ballots for him. But for Johnny Fuller, he filled it out himself. I watched him while he signed it. And all of these persons, I left the ballots with them once they were completed. So Yvonne Stustier, I think her daughter came in one or two times, but she told me to check on her mother because she was moving away and she could not do her own ballot. And she wished that I would assist her mother. So I left the ballot in their possession, and whoever mailed them, I do not know. But I think Arthur said his sister that was my son put his in the mail. And Johnny Fuller, so I had to have them in my possession, those three, because I had to assist those persons. But with Johnny Fuller, I did not touch his ballot. I just observed why he was doing it to make sure he filled it in correctly. And I just pray and trust that you will take under consideration somebody that's totally disabled. Thanks.
Okay, any questions for Ms. Dollar? Okay, thank you, ma'am.
Good morning.
Good morning.
My name is Alice Strong. My address is P.O. Box 324, Lumber City, Georgia, 31549. And I have been cited for, it says Ms.Lula Sprite said I took her ballot and she did not require any help. But she did require help. And I have a letter from her son stating that she required help because she had had a stroke. And also, she was housebound. She's an avid voter, but she couldn't get to the poll because she has a motor wheelchair, and it was torn up at the time. And I was asked to go and help her vote. But the only thing I did, she did her own marking on her ballot. But I signed the oath that I assisted her and filled out the back of the oath with her information. And I have this letter from her son.
We have a motion to accept the letter.
So moved. Second.
I've got a motion to second. All in favor, signify by saying aye. Aye. All opposed, same sign. That motion carries. And you'll just hand that to Mr. Carter.
Thank you, ma'am.
Just let us see that letter. All right, Ms. Strong, do you have anything else you'd like to add?
With no sir, because that was the only one, I did not receive a letter from the election board, but I saw someone else's letter, and I saw my name was on there, so I decided to come and to let you know what
So
happened.
you're saying that you did not receive notice of this hearing?
No, sir, I did
Okay.
not.
Any questions for Ms. Strong? Okay, thank you.
And, but also if I may, it's in 2012, this election was, the investigator, Ms. Pam Jones, came by my house one day, and, but I wasn't at home. My girlfriend told her I was at work, but she never contacted me, and she also sent me a letter. And I used to be to call her, and I called her several times, but I never got her, and I left messages on her voice. She never contacted me.
Okay.
Thank you.
All right, anyone else?
My name is Chris Stevens. My address, 16 Mimosa Lane, McCray, Georgia, 31055. And I serve as the sheriff of Telfair County. Mr. Secretary, I have a folder that has the letters that you just got a copy of, along with some other sworn affidavits. What you have is a sworn affidavit. With your permission, I'll approach and give the board.
We have a motion to accept the documents from the sheriff.
So moved.
Got a motion to second. All in favor signify by saying aye. Aye. All
appreciate the opportunity to come before this honorable board. I don't represent any particular person here, but after I looked into the facts involving the investigation of this case, I felt it my duty to come and speak to the board. I don't represent a certain individual, but I do represent law and order in my county and executing it fairly on the citizens of my county. Due to the time constraints, I had written a letter to the board, but with such little notice, we didn't get it off. So with your permission, I'd like to go over my letter and just point out some facts in case you have some exhibits attached to your folders. I hope you'll follow along and stop me at any point that I can answer a question. I will say also that the Secretary of State's office, the Investigations Division, has some of the most competent investigators in the state of Georgia. I know this because I was one of them at one time. And I know these investigators, and I work with these investigators, and they're very competent. Unfortunately, the investigator that got this case left a lot of questions unanswered. And in my opinion, this investigation was sloppily done. And I'll point out some of those instances in my letter. It is my understanding that several citizens of Telfair County have matters pending before this body. I would like to take this opportunity to address the board concerning my firsthand knowledge of the fine ethic and good character of many of the individuals named in this report, as well as the obvious investigative deficiencies evidenced throughout this case. Firstly, the complaint originated from an individual well known to my office. As a matter of fact, your complainant, John Dobson, is currently being investigated by the GBI for recklessly and repeatedly pointing a pistol to the head of a local senior citizen while threatening the gentleman's life, only because he agreed with Dobson's outlandish and slanderous rants. Closest family circle. Sworn affidavits reveal a sloppy or non-existent investigation aimed only at smearing my family. See attachment number 1, pages 4, 5, 6, and 7, which are sworn affidavits that counter the allegations made against these individuals. I've been a criminal investigator for well over 20 years. I've investigated every crime from shoplifting as a local agency police detective, election fraud as a member of the Secretary of State's Investigative Division, to war crimes as a criminal investigator working overseas for the United Nations. In every case I've ever investigated, all witnesses and all of those accused were interviewed whenever possible. An investigator should never submit to a prosecutor, or in this case, to this board, an investigative report that reflects solely the uncorroborated allegations of the initial complainant. This is not the former Soviet Union, and this is not Saudi Arabia. The agent assigned to this case had 3 years to interview all the parties related to this case. I was told the agent claimed she couldn't find them. I was told the agent insinuated that many of the individuals mentioned in her report avoided her attempts to interview them. This is simply not the case. These people are honest and forthright in all of their affairs. They are definitely not the felons this investigator has accused them of being. After casually investigating this case for 3 long years, the respondents were notified they were being accused of committing various felonies by Chief Investigator Chris Harvey, and their case will be brought before the board in 30 days. I, as Sheriff of Telfair County, was contacted by several of these little old ladies and gentlemen named in the report. Many of these individuals are some of the dearest and sweetest elders of our community, hard-working, honest, tax-paying citizens who came up through the Great Depression and fought in our wars. Some are still involved in serving their communities in some way. They are proud Georgians who up until this time believed in our system. They believed in our election process. One 92-year-old widower, a World War II veteran, often boasted proudly to his family and friends that he has voted in every election since he was 18 years old. This same gentleman told me that he will never vote again because of this ridiculous accusation against his 65-year-old daughter, a retired school teacher, widow, and loving grandmother who has never had even the slightest encounter with law enforcement. Another, Mr. Henry Carnes, a 75-year-old respondent who is also a pillar of our community, stated in his sworn affidavit, "I doubt I will ever vote again based on how this investigation has been handled. It's just not worth the hassle." You can see his statement on attachment 1, page 2. As a trained career investigator and at the request of some of the respondents, I read through the investigative findings regarding this case. I quickly realized that there was absolutely no evidence of criminal intent or fraudulent acts, but what appeared to be only minor errors in filling out the absentee ballot envelopes. I also felt compassion for these senior citizens because most are not physically or financially able to defend themselves before this board. I personally hired a private investigations firm to locate and interview the witnesses in this case and to obtain sworn affidavits from them. I merely provided the investigative firm the names of the respondents and witnesses and a copy of the complaint. Promptly, in the course of 2 afternoons, these witnesses and respondents were interviewed and sworn affidavits were obtained. The private investigation revealed that the first time many of the respondents were notified of these accusations was when they received notice from Chief Chris Harvey less than 30 days before the hearings. It also revealed that at least some of the respondents repeatedly reached out to the investigating agent after her card was left on their door and left messages but never being contacted back. At least one lady, Mrs. Carnes, a 71-year-old lady, see attachment 1, page 3, reported that she recently contacted Chris Harvey directly. The respondents and witnesses in this case obviously did not elude investigators, but instead attempted to reach out to them. There are several factors responsible for any errors that may have been detected by the state's investigator in this case. However, even the slightest insinuation of criminal intent and or fraud is grossly unjustified and not supported by the facts. At best, many of the scenarios described in the investigator's report can be attributed to common errors and innocent mistakes. Mistakes such as poll worker did not check the box that an elector's driver's license was inspected 33 times countywide. Out of 35 ballots cast, that's not bad. Elector did not fill in the blank for the street address, 18 counts countywide. Elector signed their name in the wrong line, 1 count. Poll worker did not check the box that elector was physically disabled, 10 counts. These and similar violations go on and on to equal some 162 counts. I think this board would agree that the fine print regarding the oaths on the absentee ballot is very tiny at 1/16 of an inch. You can see an attached sign. The oath of person assisting elector states that only if the person assisted in marking such elector's absentee ballot are they required to sign the oath. Obviously, the investigator assigned to this case also had trouble reading the fine print, as many of those accused of committing a felony by not signing the oath had not assisted in marking the elector's ballot. They may have assisted in filling out the oath of the elector and are assisted in addressing the envelope properly. But in most cases, signing the oath of a person assisting elector is not required. However, if an investigator were to ask an elderly elector or if anyone helped them fill out their ballot, of course they'll say yes, because in their mind they did have help with their ballot. The help was in filling out the oath and address correctly, and maybe applying postage for it. When the private investigator specified to witnesses using exhibits to demonstrate what is considered assistance with their ballots, they quickly clarified their answers, and not one of the witnesses interviewed thus far has corroborated any of the accusations of wrongdoing. We also had a new and at that time inexperienced registrar who had a lot to learn rather quickly. She was in constant communication with the Secretary of State's office staff as she navigated her first election, nervously trying to do everything just right. I'm sure she probably made a few mistakes, but after this horrible experience, she will probably seek other employment. There is not one single element of this case that rises to the level of election fraud. There's not one single element that can support any claim of an elector not freely voting for the candidate of their choice. There's not one single element to support any claim of an eligible voter not being allowed to cast their vote. There's not one single element to support political corruption in our county. I would bet that if the state investigators scrutinized any county election in this state as closely and as for long as they have scrutinized ours, they would find a similar number of these mistakes and probably more. People are not perfect, and temporary employees who may work one election day every few years long as they err on the side of not denying a single eligible voter to cast their ballot, we have accomplished our goal as a free democracy. I feel it's very unfortunate that innocent, law-abiding Georgians can be dragged before this board and accused of committing felonies when a fair and competent investigation has not been completed. These matters will forever be a part of the public record, and these good and proud members of our community will forever be shamed and ridiculed for being undeservingly accused of criminal behavior by having their names attached to this report. I am hopeful that members of this board, Secretary along with our legislators, will explore measures that might prevent other Georgians from suffering through such an embarrassing ordeal in the future. Best regards. Attached to my letter, you'll find several sworn affidavits that clarify and contradict the information that you've been presented by Investigator Harvey in his report. Sworn affidavit can stand up in any court of law anywhere. To give you an analogy of what has happened here is we had a gentleman, we're known for our big deer and world record bass in my part of the state. This gentleman lured an investigation down here with tales of the big game we have. Well, once they came looking for that big game, they didn't find any because the guy was a fraudster. So before going back with an empty sack, they stopped off and bought a few packs of bologna. And that's what you have here is bologna. You can't make big game stew off bologna. I appreciate you all giving me the time to address you. It's upsetting to me. We've had so many negative issues surrounding our county historically. We've got new people in office. We're trying to change things because our economic plight is so bad. We don't have much industry. And we'll take the rap for what we do. And we'll punish those that have violated the law. But in this case, I'm telling you, there's nothing here. This was a fish expedition. When the complaints didn't pan out initially, for whatever reason, they decided to dig until they could find something. All you've got here is a few mistakes. And if you've ever been involved with filling out one of these absentee ballots, I'm sure you've made a mistake too. But I hope the board will consider the evidence that I presented. This case has not been adequately investigated. Witnesses have not been adequately interviewed. This case was thrown together. It was sloppily done. And innocent Georgians have been dragged through the mud by being attached to this report as a result of that. And I think that should never happen to any Georgian or anyone in this nation as part of that case. I appreciate your time, and any questions you may have of me, I'm glad to try to answer.
Any questions for the sheriff? No questions. Thank you, Sheriff. Anyone else wishing to speak? Yes, ma'am.
Good morning. My name is Linda Floyd. My address, 180 Spalding Drive, Mayville, Georgia. I also received a letter. I didn't understand it, but they said that I assist Mr. Albert McCray, and it was May Mack. During that year, for as I can remember, if I assist anyone with their ballot, I will sign my name. I can't remember back in 2012. I just wanted to come and say, if I assist someone, I did sign my name. Thank you.
Okay, any questions for Ms. Floyd? All right, thank you for being here. Anyone else? All right, Mr. Harley.
Hurts me. My county commissioners, Mr. S.O. Jones, Mr. Joe Wingate, and Mr. Howard Lawson find nothing wrong with this. They find nothing wrong with this. How much can one community endure? to have the right to have our votes cast and counted for who we want to represent us.
Anybody else wants to bring up anything else?
Anyone else? All right, Mr. Harvey.
Yes, sir. Mr. Secretary, could I respond to the sheriff's comments?
Yeah, I'm gonna let you do that. I got a question for you.
Yes, sir.
We had one, I'm trying to find my notes here, we had one person that said that they weren't noticed.
Yes, sir.
Do we have record of sending the notice?
We do. We've got, we scan all the notices that we send out before we do. I don't have all those copies with me, but we can certainly correct, or we can certainly verify that a letter was sent. You know, whether it's a good address or somebody has changed or it gets lost in the mail, but we can verify every respondent has sent a notice.
Yeah, I just want to make sure that it's clear that we did notice.
Yes, sir.
The individuals, so they could be here this morning to give us their side of the story. So,
Yes, sir.
Yes.
If I may respond to Sheriff Steverson, I think I understand Sheriff Steverson's passion. However, I think his argument proves our point and discredits his own point. His basis seems to be that these are all good people and that the complainant is a nut, I guess, to paraphrase what he said. And we shouldn't have considered the allegations of a nut, and we should have known better, and we should have somehow made some sort of subjective analysis that, well, this person is making a complaint, and we should have known that he was crazy and not done anything about it. Instead, what we did is we took the complaints from this person, and we don't know anybody in Telfair County, whether they're, you know, unhinged or they have an agenda. Mr. Steverson made a complaint also that we investigated. We investigated the initial allegation about absentee ballots. How you investigate absentee ballot fraud is if there are specific people that are alleged to have had their ballot taken, you go talk to as many of those people as you can. If those names don't come up, you've got two choices. You can either say, sorry, nothing we can do here, or you take the extra, additional, and very time-consuming step of getting copies of all the absentee ballot applications, copies of the absentee ballot envelopes, going through them individually, identifying voters who have some type of discrepancy, randomly interviewing voters. Now, he indicated that we sort of randomly selected the people to interview. We did not. We randomly selected absentee voters, and we interviewed them, in many cases on tape, with an standard interview form, with experienced law enforcement investigators, and I would certainly dispute the allegation that Investigator Jones is anything but a top-notch investigator. She is one of our best investigators, and I would stand behind her 100%. But we interviewed these individuals. From these individual interviews of the voters is where we got the names of people that had supposedly assisted them. And contrary to Sheriff Steverson's understanding, filling out an absentee ballot envelope, oath of elector, is assisting under the law. So if somebody fills out an absentee ballot envelope, they are assisting the voter. He indicated that was not a violation of the code. I put to the board that it is, and that the board has always upheld that it is. The fact that the names of the people assisting came back to the investigators, and we went and made contact with as many of those people as we can, and again, over 45 interviews, letters sent to people. Yes, there were some people that we were not able to contact, and people that didn't respond, and opportunities that might have been missed indicate. But anybody, by any objective standard, looking at what we did, can say that we did exactly the opposite of what Sheriff Steverson suggested, that we went out to tar and feather somebody or to brand somebody's name. We followed the evidence regardless of who was involved. As a matter of fact, it was, I think, 2 days ago that when Sheriff Steverson contacted our office, I didn't even realize that one of the respondents was Sheriff Steverson's mother. There's no specific indication that that's the case. And I called the investigator and said, hey, in going over this case and getting ready, I see there's some connection, there's some mention. Is that person a respondent? And the investigator said, yes, it's this person. So there was no attempt to brand anybody. There was no attempt to go after anybody. We simply followed the voters who related their experiences with absentee ballots and led us back to the individuals that assisted them. So the fact that we followed the facts, and again, to say that we have somehow branded these people as felons, before this meeting today, the board will hear 25 to 30, 40 cases of individuals who are accused of doing the exact same thing that these individuals are doing. No specific recommendation has been made, nor will be made, that any of these people are handled any differently than any other people in the same circumstance. And I think the board would recognize that that's the case. If somebody illegally possesses an absentee ballot, the board has had a very long-standing practice of generally binding those people to the AG's office. The board can certainly vary from that if they want, and I don't need to tell the board what they can do. But I understand his passion, and I understand that it's unfortunate that people that presumably have good intentions, and I have no reason to believe that any of these individuals who spoke had the intention of doing anything wrong, but the fact is, in some cases, they didn't sign as assisting. When they may think they did. We've got copies where they did not sign as assisting. I'm completely confident in submitting this to the board, and the board taking action on it, and if the board decides to send it to the AG's office will have sufficient evidence to take appropriate action for these violations. And again, just lastly to say, this shows there is no consideration of who the respondents are. We follow allegations and we follow violations, and when we find a violation, we make a citation. We've cited state senators, we've cited state representatives, we've cited candidates, we've cited family members.
Any questions for Mr. Harvey?
Mr. Harvey, look at the oath of the only person assisting elector.
Yes, sir.
Carefully. It says that I've assisted the elector marking such elector's absentee ballot as such elector personally communicated such elector's preference to me. It doesn't say anything about filling out envelopes or putting addresses on envelopes. This is talking about assisting the elector in choosing the candidate, just like the sheriff is said. Now, if the oath should say something else, then it needs to be amended on the form. But this just says that you're helping mark the ballot. And we've heard, and I don't know that your investigator went that far in her investigation to determine whether the assistance was marking a ballot or just filling out an envelope or putting a return address on it or something like that. And I think it makes all the difference in the world.
Well, sir, respectfully, under 21-2-2 definitions, ballot, and I'm reading from the code, ballot means official ballot or paper ballot and shall include the instrument, whether paper, mechanical, or electronic, by which the elector casts his or her vote.
Right, but you're not reading what the oath says. The oath says, it doesn't say anything about saying that you have to, this oath doesn't say that I help
The oath says,
another part of the ballot.
Yes, sir.
It says making the choice of the candidate the elector chooses. Now,
Yes.
if you didn't do that, why would you sign this affidavit? Because it doesn't say I helped in any way with the ballot.
well, it says ballot, and under the definition of ballot, the envelope counts as a ballot.
Yeah, but you gotta look at what the oath says, not
Yes, sir.
what the statute says.
I understand, sir. And if the board, wants to, direct us to follow that, this is the standard that we've used for years, and we can certainly reconsider. I can talk with Mr. Willard if that's something we need to reconsider. I think if you look at the memorandum of interviews that we did, they do indicate in pretty great detail what the person did. the person, and you don't have that, but I'm talking in these files, when we do interviews, we do a question and answer form, and then it's summarized by the investigator. In some cases, it's audio recorded, and the investigators do go into specific detail about what was done. And in many cases, it was just that. It was that the assister marked the ballot envelope. And if the board doesn't believe that that's a violation, we can certainly adopt that. But it's been the standard practice that is considered assisting with an absentee ballot.
Regardless of what the standard practice is, looks like to me we need to go with the language of the oath rather than some standard practice. Particularly when some of these affidavits says, my daughter-in-law only filled out the mailing envelope in order to mail my absentee ballot. Doesn't say the daughter-in-law helped her select her candidate.
That's right. And in some cases,
that I helped select the candidate.
and in some cases, I understand individuals have told us that they gave the ballot to one of these individuals, and now I'm hearing that the person has recanted and now is changing their story, which is something that would have to be determined at trial or determined witness credibility. I've not seen those affidavits, so I don't know what they say, but I had a call when Sheriff Stevenson said that Ms. Carnes called me. She called me, I think, Tuesday this week. She was interviewed in 2013, so she was interviewed. She may not have remembered being interviewed, but we've got a documented interview with her at the time. Like I said, we've got 3 accordion folders full of interviews and evidence and documents that have gone through to come up with these. And again, that's been one of our applications of assisting with absentee ballots, and if that's incorrect or improper, we'll make changes immediately. But and I would argue, I guess, or I would submit that Mr. Willard could determine whether or not, if the board wanted to send it over, whether or not that's something that he could proceed on. But the allegation that this was some kind of sloppy, haphazard witch hunt investigation is completely belied by the facts.
I'm not saying that.
I understand, sir.
All I'm saying is look at oath, look at what oath says to determine whether or not there's a violation of the law.
I understand.
That's all I'm saying.
Yes, sir.
All right. Any other questions for Mr. Harvey? Ms. Jones, I'd like to ask you a couple of questions, if you don't mind. Just give us your name, address for the record.
Pam Jones, investigator for Secretary of State's Office, 237 Coliseum Drive, Macon, Georgia, 312.
I had a few questions I wanted to ask you. How long have you been an investigator for the Secretary of State's office?
6 years.
6 years. Do you believe that when you were doing this investigation, you were one-sided in it?
No.
Do you believe that you randomly selected the individuals that you talked to or interviewed in this process?
I know it is. Yes.
And why would you do that?
To get an adequate sampling of the alleged violation. So that not to take too many people from one district. I went through the stack of applications or ballots, and like every 5th person pulled the application to review. And until I could get the number that I needed.
So when I say randomly selected, it wasn't like you just went down there and picked the people that you thought you should talk
No.
to. You had a process on how you would do the investigation.
Yes,
That
we
would give-
decided that 20% would be an adequate review. In discussing with our supervisor and Mr. Harvey, we decided 20% would be sufficient number.
Do you feel like anybody has been dragged through the mud on this investigation, or have you handled this like you've handled the other investigations that you've done in the 6 years that you've been working for?
It's been handled exactly the same way. There's been numerous investigations regarding the same allegations, and we always handle them the same way.
Could you tell us about how you went through the contacting process of the individuals that claimed that they were never
issues sometimes in getting our green cards back. Lost some mail, we have a huge mail run here, so that's the case sometimes, so.
Okay. Anybody else have any questions for Ms. Jones?
When you interviewed these people, did you ask them exactly how they assisted the person with absentee ballot?
Yes, sir.
How many of them, or do your notes reflect which ones said that they assisted in selecting the candidate?
I would have to review the MOIs because that's usually done as a collective number, because we've always treated assistance, including the ballot as well as the ballot, because it's considered one document.
What's confusing here, it says your findings in your report just say that they assisted, it doesn't say how. You see where we are.
And that's something that can be reviewed. We can review the MOIs to tell the difference, but because that is a specific question that's asked, but typically that's considered a violation because it's considered one document.
And the MOIs, not to interrupt, but the MOIs do generally indicate if the person assisted, they helped me choose the candidate. In some cases, I believe Ms. Studdard was blind, and she said that, I think it was Ms. Dollar, whoever assisted her, she told her who to assist. And so it indicates in the MOI that Ms. Dollar marked the ballot for me and then showed me what assignment. So if you look at each individual interview, it generally indicates to what extent they assisted.
Thank you. All right, anyone else wishing to speak that hasn't spoken? All right. Sheriff, do you have something you wanted to add?
I'll just add that, in the report that you all have, it says basically that the complainant's allegations could not be corroborated. At that point, I don't understand why they went on such a fishing expedition when they brought us all here today with a bunch of errors on the voting process. And also, if one does not understand the law or the rules for the absentee ballots themselves, I don't understand how they could be expected to investigate it and bring these good people before this board. As I'll stand by that this investigation was done sloppily. This investigator has no criminal investigations experience besides her experience since being hired with this board. And there's a lot more that could have been done. And you all must agree with me that the verbiage on the absentee ballot part of the oath is very confusing. And you'll have hearings from now until the end of time to cover everybody that makes mistakes on those. These people try to do the right thing. They're not criminals. They don't have criminal records. They don't have criminal histories. And it's unfortunate that they're here today.
Thank you, Sheriff. I would just say that these technical errors on voting and forms and procedures, we have laws, rules, and training for a reason. And we've had cases before where we've had people that didn't do those things properly, which calls into question those ballots and those votes. And I know the sheriff and I would both agree as elected officials that if the election doesn't go the right way, we can have elections contested over such matters. So I would disagree with allowing small details to slide in the elections process, because it can create some big problems down the road. Just hold on one second, ma'am.
Mr. Chairman, I may not should interject this because I don't know anything about the absentee ballot situation. My client's not involved in that. But I just feel like I need to get this out there when Ms. Jones stands up here and says that she contacted everyone or attempted to. The former election superintendent, who was the election superintendent at the time, was not contacted, and she's been living at the same address in Helena and has the same phone number for 30 years. Just want to get that out.
Yes, ma'am.
I'm Bureau Dollar.
Ms. Dollar, you got to come on back up here to the microphone for me.
I'm Bureau Dollar, and I want to find out if it's proper for the investigator to harass and intimidate relatives that are deceased about an absentee ballot.
Well, ma'am, I think if you have a complaint about somebody harassing or anything
No,
like that.
investigate, yeah, what I need to write to the
Yes, ma'am.
Secretary of State.
Yes. Do you have anything else you want to add?
No, sir, I think,
Let me ask you this, on the more serious potential allegations, do you feel like it would be beneficial for us to table those parts of the case where you could pull out and look at, you know, the investigative documents and give the board some more detail in the future on those? Or?
well, I don't know that, that would necessarily be helpful. My thought is with the allegations that have been cited are pretty clear, and if it's determined that those are not good citations, then I think the easiest way to go forward would be for Mr. Willard to evaluate each of them, and then, you know, close cases or dismiss respond as necessary. You know, Sheriff Stevenson said that, you know, there is no real fraud going on down there, and you know, frankly, we didn't find evidence of real fraud down there, and I don't dispute that with him as far as our evidence goes. But you know, as you said, you know, little things matter in elections, and details are important, and I don't know that there's going to be any more detail that we could gather. I think maybe a better use would be for to us, maybe in consultation with Mr. Willard, if you bind it over, is to, you know, determine, you know, how far this assistance gets pressed, or clarify that, so that, you know, we can look at each case, because in some cases people did say that this person marked their ballot for them. In other cases, as Judge Simpson said, they admitted addressing the envelope. And I think if we use this case as a marker to maybe clarify those standards, that may be more beneficial than us just going back, because essentially what we would do would be go back to pull out the MOIs and say specifically, okay, this person did this, and all that information is already in here. So I don't think there's anything else we can do.
Well, I guess my question was if you thought the board would benefit from seeing any of that in light of everything that's going on.
Certainly, I'll be happy to do anything the board wants. I think as by way of resolving it, again, if Mr. Willard were to go through and say, hey, this person, based on this level of assistance, does not constitute a violation, that will be sort of a marker, so the board will see, you know, because of course the board will have to agree with that when Mr. Willard brings it back, say, hey, we're dismissing this case against Joe Smith because all they did was address the envelope, and that's not a violation. And I think that'll distill this back out. So we've got, you know, approximately 10 respondents on various charges of assisting and possessing. And I think when he brings it back to you at some point in the future, you can say, okay, we're recommending you dismiss these 3 people because the only thing they did was address the envelope.
Do you have any response to Judge Johnson not being contacted?
I don't, except that I know we contacted we contacted 4 out of the 5 poll workers at the precinct where there was an allegation. I don't have a response to that, and that would not be something that would normally be an omission that we would make. The only other thing I would say, I guess, is that the absentee ballot issue is handled by the registrar, so I think that was more of our focus. But in hindsight, yeah, talking to the election superintendent regarding the voter certificates would have been would always be advisable.
All right, anybody else have any questions?
Well, Mr. Chairman, I had a position, and then possibly some questions. I tend to agree with Mr. Harvey that there's enough evidence here that's been raised, even though there's affidavits that have been presented in opposition to it. It seems to me that the most efficient way to deal with this case would be to bind a lot of it over and have Mr. Willard look at these affidavits and the other information that the investigators have brought forward. And there are a couple of things that I would like Mr. Willard, just speaking for myself, not the board, to a couple of issues to look at. One
In every case where somebody is cited for possessing a ballot, the voter has told us that person who assisted them took the ballot with them. So that nobody is cited for possessing, for merely touching the ballot while assisting. So anybody who's cited as possessing is alleged to have taken the ballot in their possession away from the voter.
Well, I would like Mr. Willard to look at the issue of how that really works as a practical matter, and is that really what the statute intends as a violation for somebody who's allowed to assist, but then can't walk the ballot to the person that they're assisting's mailbox, which seems to be
I understand.
an issue. So that's generally the position I would take. It may be that there are a couple of these people and issues, as Mr. Harvey has suggested, that could be dismissed at this point, and I'd be happy to look at those. But generally speaking, I'd vote to bind it over, and I was also particularly disturbed with what appeared to me the large number of voter certificates.
Anybody else?
I'd just like to say, I think absentee ballot area is the one area that we have to be very, very careful about looking at. We need to look at it under a microscope, because that's where fraud is the easiest to perform, and it's the easiest to affect the outcome of elections. That is an area where voters are most vulnerable. That's an area where it's easier to commit a voter fraud than anywhere else. And I think we need to be especially careful in that regard. But I do think that we have a problem in this case about not knowing, based on what we've been provided today and what the sheriff has provided us, whether or not these people that assisted and didn't sign an oath are really in violation of the law or not. And without knowing specifically, in my mind, whether somebody helped an elector check a candidate or just addressed an envelope, it makes a world of difference. And secondly, I don't see how someone that is blind and homebound, the person assisting that person that takes the ballot with them to mail it, how's that person going to get the ballot back? How's the disabled person going to get the ballot back if you don't have that transmittal by the person assisting? And I wonder about that. And also, what bothers me is to make sure that every citizen gets the opportunity to vote, particularly those that are disabled and can't do it in a normal manner. And we need to be very open to making sure that the assistance they get and that they get the same protections that all the other voters are getting casting their ballots. But under these circumstances, with regard to these assisting charges and things like that, I don't think I could vote to bind this case over based on this record. And the second thing is that with regard to the superintendent and the board of registrars, Roy Sawyer has done a good job in her response, and shows that the county has taken substantial remedial action already. And I wonder if this case, if that portion of the case is bound over, I would encourage an attempt to come to a consensual resolution of that based on the mediation that the county has already taken. I think services.
Mr. Willard, would you mind, or if you can, explaining, who can legally assist and who can legally handle the absentee ballot?
I can point you to 21-2-385, Mr. Chairman. A physically disabled or illiterate voter may receive assistance in preparing the ballot from any one of the following: an elector who lives in the same county, an attendant caregiver, or a person providing attendant care, a relative, defined as a mother, father, grandparent, aunt, uncle, brother, sister, spouse, son, daughter, niece, nephew, grandchild, son-in-law, daughter-in-law, mother-in-law, father-in-law, brother-in-law, or sister-in-law of the disabled or illiterate elector. That's who can provide them with assistance in the ballot. I will confess, Mr. Chairman, this is the first time I've ever seen a case in my representation of the board where we've dealt with, they're not telling them who to pick, or they're not helping them write who to pick. There's some allegations that they just filled out, return address. And I was talking to Mr. Harvey during the presentation, and while Simpson raised the issue of the oath, that is corroborated by how the General Assembly has defined 385B, where they distinguish a person assisting them in completing the ballot, and then they mark that assistance on the envelope. So the General Assembly has bifurcated the terms and refers to a ballot, and then refers to the envelope that you execute the oath on. So I think the General Assembly has, whether you argue it's through omission or what, has said it is not assisting an elector if you're making a mark on the envelope. You are not assisting them with the ballot. I think that's clear on both the language of the oath as well as in 385B. Now, I think you also asked, and Mr. Worley had alluded to it earlier, who can actually possess the ballot. And, Mr. Chairman, I've had some colloquial conversations with representatives from your office. We're going to be coming back to the board with a bundle, presumably at the next meeting, where we're going to be taking a position on that. But it's going to be premised on the use of the terms the General Assembly has elected to use. And they talk about that the elector must mail, and then they employ the disjunctive or, and then they employ the term personally delivered. The adverb personally does not modify or relate to mail. And I think that's critical when you look at the rules of statutory construction. And so I think the General Assembly has actually taken care of the issue of how a disabled voter or an illiterate voter actually as well gets their ballot back to election officials. And that is, they have not restricted mail to include the term personally. But like I said, we do not have those cases from our office.
I
With a recommendation back to you, but I think that's going to be where our advice is going.
Well, I mean, I guess my question to that would be is in the past, we've had people that have maybe not filled the ballot out, but they have taken bundles of, 50 absentee ballots and mailed them, and we've cited them and, come to a consent order with them that they violated the law being in possession.
I understand, Mr. Chairman. That's why I'm not saying that as a matter of law, I'm telling you today, you can't bind these cases over. I'm just saying that this is probably going to be a full and vigorous conversation with the board at a point in the future. But the General Assembly has employed specific terms. And I have talked to Ms. Brumbaugh when she was with our office, and then when she left our office and was working on legislation about this issue. She's been cognizant of this fact. And the General Assembly is considered to have known what it meant when it used the adverb personally to modify only one of those words.
Well, I think, at the end of the day, we've got the law and the state election board rules that we, have to have them followed and we have to enforce. And one thing I think that I've seen, I know in the 5+ years that I've been chairing this board, is that we've been very consistent on how we handle these type things. And I think that's good for us as a board. I think it's good for the elections officials, and I think it's good for the public as far as us having secure, accessible, and fair elections. And when we start kind of picking and choosing how we're going to do that, I think can get us into some trouble down the
There was, I recommended that for Inez Carnes and Martha Williams, they received letters of instruction for assisting without signing. They assisted their husbands, and I think,
That's incorrect.
sir,
That's not correct.
our evidence showed that they
For
assisted their.
96-year-old
All right,
father.
Sheriff, we're gonna stay orderly here. With that, we're giving everybody an opportunity to speak, so.
Who was their father, sir?
So anyway, that's the recommendation as regards them with the assistance, letter of instruction.
And what was the reason again for the letter?
Well, again, because it was a family member. It was, you know, I think in the past the board has viewed a distinction between assistance, you know, among family members that might technically be wrong when you don't sign, but it's different than a candidate or a member of a campaign coming and assisting somebody. I think.
So you're saying that this is more of a technical violation, and in the past we have written letters to make the technical violators aware of what the law is, and information purposes. There's no other penalty along with that, correct?
Correct. Just a letter restating the requirements for assisting a family member.
All right, you want to keep going on down a little bit.
The other question that I had related to Fred Heyman.
Yes, sir.
And this idea that there was a charge against Linda Cartwright that she had permitted Mr. Heyman to vote. And the testimony was that what was presented was that another poll worker and not Ms. Cartwright handled that. How do we generally handle these cases?
Usually the poll manager is the person, because so often in the course of a day, different people do different jobs, and it's impossible to determine who gave him his card or checked his ID. So the poll manager is generally cited for an event like that.
What was the recommendation on Mr. Haynes?
That he be bound over also for voting while unregistered.
So he was not registered.
Correct.
And he voted because they used the other name.
Well, he went in to vote, and he put his name on there, and his name happened to be the same as his grandfather, who was registered to vote. So they pulled up Fred Heyman and said, okay, you appear to be at this address, so they gave him a card, and he voted.
So he voted not being a registered voter.
Correct.
Well, and I guess the sheriff indicated that it was either he did or it was possible that he had received his grandfather's or his father's new voter registration card and voted on that basis.
Yes, sir.
Mr. Chair, may I clarify something about Mr. Haynes?
Yeah.
I was told that Mr. Haynes, his father, when he became deceased, the board or the elections commission or whatever took the wrong name off the registration form. I'm under the impression he was registered and it was mistakenly purged, so when he went to vote, he was allowed to vote.
And I'm sorry, Tony Sargent on behalf of the Board of Elections and Registration. Again, there were 3 Fred Haynes registered at the same household. Fred Haynes III did not pass away until August of 2012, which was after the July primary. There were 3 Fred Haynes at that one address, and that's where the confusion came in. There was the senior, who was however many years old, 90-something years old. There was Junior, who may have been deceased, and then there was the third, which is the grandson, which is where the issue arises.
So the grandson was registered.
Yes, sir.
Then was taken off the rolls because the registrar thought that he had deceased, mistaking him for either the senior or junior.
Junior probably his father. But then with the car, I guess, and again, I wasn't there at the time. I only know what, I was advised by my client, which unfortunately they weren't able to be here because of doctor's appointments, of spouses, family members. But, the confusion came about with just the name Fred Hangman. You know, it didn't have junior, senior, the third. It was just Fred Hangman. And they didn't check the birthday, unfortunately.
According
You
to the
also
report,
got the issue with the registrar.
well, according to the report, he was not registered. Fred Hammonds III was not registered, and he wasn't registered at the time when he was interviewed in September of 2013. And at that time, he was advised by the investigator that he still wasn't registered to vote.
But was he registered before and was taken off by mistake? Is that what happened? I'm trying to figure out what happened.
We can, during a break, we could check to see if he was ever registered before, but again, based on this, on the report, he was never registered.
Well, I can follow up with my client, just to make sure and provide the information with you all.
All right, did you get your question answered about the poll man? Okay. All right, good.
Thank you.
Thank you. All right, Mr. Harlan.
Well, actually, I do have one. When we get to the point of discussing who to bind over, what to bind over, Ms. Carnes and Ms. Williams, would be my preference not to send them a letter of instruction until we've figured out exactly what the board's position is going to be if we advise the Attorney General on these kinds of issues. Because I don't want to send them a letter of instruction, even though it's only a letter of instruction, I don't want to send them a letter of instruction if it's turned out that they really didn't violate the law.
The affidavits we have said they only filled out the envelope. Ms. Carnes only filled out the envelope. She didn't help with selecting the candidate. So I would agree. I would not be in favor of that or his whether I would be in favor of dismissing those two.
And to, Mr. Chairman, to avoid any confusion about what I said, and I realize that sometimes I'm a little obtuse in what I say, in terms of signing the oath and assisting on the ballot, there's no equivocation on our part. If you do not actually assist them on the ballot, if all you do is assist them in filling out the envelope, that is not something that they are required to execute the oath for.
That would give the Carnes dismiss. Any of the others, if that's the case.
You want to go back through the recommendations?
Well, based on that, it might make more sense to, and it may be something that we can do in the background of this meeting and bring this back up at the end of the meeting and get those answers to who exactly did what with this assistance. And so we may be able to resolve it later today. If you want to table it temporarily, we can come back with each of these individuals and say, okay, this person assisted with the actual ballot and this person just signed the envelope, and that will answer your questions. And while I can't do that right this second, we can certainly get that done in the next hour or so and bring it back later this afternoon and resolve it that way.
All right, well, let's do that. Let's take a lunch break. It's 12:35. We'll try to come back at, I guess, 1:25. We'll take a lunch break till 1:25. Give us what you got from break.
We're still compiling the specific issues with the assistance. We should have that very soon. I can say that we checked the statewide voter registration system, and the person who voted in his father or grandfather's place, Mr. Heyman, I believe, has never been registered to vote. So Fred Heyman's voted when he wasn't registered to vote through the error or the fault of the election people who apparently mistook him for a family member.
The Secretary, may I speak?
Yeah, hold on one second. So do we know why he went and tried to vote? I mean, do we know if he got the card and just thought he was registered for some reason?
I believe that's what Ms. Strong or somebody mentioned earlier. I don't remember, there have been so many people talking, I don't remember who said that he moved into his father's grandfather's house and a precinct card had come, and so he thought he was entitled to vote, and he went, but according to the state records, he's never been registered to vote.
Okay, Ms. Sawyer.
Yes, sir. And I think Mr. Marchant made that statement as far as a registration card coming for Mr. Heyman. I did speak with my client, and Mr. Harvey is correct. I was a little confused too. But Fred R. Heyman III had not been registered to vote in Telfair County. He did vote at the July primary as a result of, again, the voters list just said Fred R. Heyman. There was no distinction between the junior or senior. The person, the poll worker, just did not check the birthday.
Okay. All right, thank you. All right, well, do we want to try to take some action here where we can until we get the rest of your report?
Well, I've still got the recommendation regarding the county and the election officials and the.
Well, do you want to go back through that again for us?
Regarding the Telfair County Board of Registrars, Rebecca Widener, Betsy Johnson, Linda Cartwright, be bound over to the AG's office.
Well, why don't you go through on the potential violations page, just go
Okay.
down through there so we can get refreshed on it.
Okay.
I think we've already talked about Ms. Cornez and Ms. Williams.
Right, and then Clemens, Vaughn, Strong, Dollar are pending the review. Heyman's, I would recommend being bound over for voting while unregistered, as well as Cartwright for allowing him to vote while unregistered, and Ms. Johnson for the voter certificates, Judge Johnson for the voter certificates, and the Board of Registrars and Rebecca Widener for the failure to certify the absentee ballots, I'm sorry. Now, I would point out, and I forgot to mention, the last violation we have under them, for not rejecting the absentee ballot application without a date of birth, I think that should be dismissed. I don't think that's I think the law requires there be sufficient information to identify the voter, but there is not a specific requirement that a date of birth be present. So I would actually make a recommendation that last count regarding Mason Spires be disregarded or dismissed.
Where is that?
It's at the very bottom under Telfair County Board of Registrars, Rebecca Widener, and it's the second charge. The first one is for 4 counts for the acceptance of the ballots, and right below it talks about the absentee ballot application of Mason Spires.
All right. Do we know if Judge Johnson's coming back?
Yes.
Her attorneys.
Oh, they are. much longer you think it'd be before we have the other information? You know?
Can you check it down? I'll get you an estimate in just a second, sir.
Does the board want to go ahead and take any of these issues up that we can while we wait? Everybody have a motion?
Mr. Chairman, I move that we bind over Fred Hammonds and Linda Cartwright, poll manager, Eddie Johnson, criminal judge, election superintendent, and Telfair County Board of Registrars, and Rebecca Widener. On the chart is set out for them, except with regard to the charge of accepting the elector's ballot without the date of birth, which I recommend be dismissed.
Okay. We got a motion. Do we have a second?
Second.
Mr. Worley seconds. Any other discussion? All right, hearing none, all in favor signify by saying aye. Aye. All opposed, same sign, and that motion carries. Thank y'all for being here today. Sorry that took so long. Mr. Harvey, do you want us to move on while we're waiting?
I would recommend we do.
Okay. All right, let me, we'll call the 2012 number 38, the Fulton County Soji case, which is, I guess, number 38 in our binder. All right, Mr. Harvey.
This is Fulton County, one of the respondents was Mr. Shoji. The board heard this case in the last meeting, and Fulton County was not noticed, so we re-noticed Fulton County. This was the case where a non-U.S. citizen, Mr. Shoji, had registered to vote. He filled out, hand-completed an application, marked that he was not a U.S. citizen. He his application was accepted by Fulton County. He was registered to vote, and he voted, I believe, 5 times in the course of about 13 years. The board dealt with Mr. Shoji last meeting. Fulton County is being cited for the violations of failing to reject the application and allowing him to vote, even though he was not properly registered, or he should not have been registered to vote. And I believe counsel for Fulton County is present. They submitted a response yesterday. I don't know if she's still here or not, but in her absence, I would submit to the board Fulton County's response regarding this issue.
What was in the response? Do you have a...
Briefly, they said that the violation associated with the alleged failure is almost 14 years old and is time barred, and then that Fulton County was required to allow him to vote because he was in the voter registration system, I think is the basis of their argument. I think she says that as far as the application goes, while the application box does have the no box check in response to the question, I am a citizen of the United States of Georgia, there are also initials in very close proximity to the check mark. They don't have any, the employee that handled the application doesn't have any specific recollection. So I don't think that they're really denying that it maybe should have been rejected, but they're essentially saying that it happened a long time ago, and then once he was in the system, they didn't have any choice but to, and there was no reason for them to question him being in the system, so they let him vote every time he showed up to vote.
And how is it we found out about this again?
Mr. Shoji actually reported to our office. I don't remember the exact specifics of what brought him to our office, but he came and somehow learned that he was not supposed to be registered to vote, so he basically turned himself in. And for the record, I'll submit this to the board on behalf of Fulton County.
And the attorney was here earlier, correct?
I believe so, yes, sir.
I would think we might wanna just hold on for a minute and see if she comes back for some reason. I'd hate to move on this and her not be able to address the board. Y'all have anything to add before we move on?
No, sir.
Let's go ahead and move, do we have any other information yet on anything else, or?
One second, sir.
Okay.
I do have a report on the rest of the Telfair County. As far as,
All right, let's, we'll go back and try to deal with that where we can get these folks on the road here. Okay, go ahead.
all right, as far as Linda Clemens Floyd, she actually assisted with the ballot itself and took possession of the ballot. Patsy Vaughn took possession of 2 ballots, but did not, and I don't believe she was alleged to have assisted this. Patsy Vaughn took possession of 2 ballots. Beulah Dollar.
Let me ask you, when you say took possession, what are you saying there?
The voters are saying that she came to their house and they physically handed the ballots to her to presumably deliver. But she did not assist them in marking the ballots. And I believe that neither of those voters were disabled or handicapped.
So you're saying that would be illegal assistance?
Well, no, I'm saying that'd be illegal possession. I think she's just cited with possession. Beulah Dollar marked 3 ballots and had possession of 4 ballots. And in addition, one of the voters, Mr. Freeman, said that he just gave her the ballot. He signed the envelope, and he didn't even vote his own ballot. He doesn't know who she voted for. Alice Strong helped fill out a ballot and transported a ballot. And then, as I think I said, Carnes and Williams both assisted only with the envelope. And I believe that covers them.
What about Martha Williams?
Only assisted with the envelope.
All right. Board have anything else? Motion?
I'll make a motion that the charges against Ms. Carnes and Ms. Williams be dismissed.
Second that.
All right, got a motion and a second to dismiss, did you say Floyd and Carnes?
Carnes and Williams.
I'm sorry, Carnes and Williams. Any other discussion? Hearing none, all in favor of dismissing those signify by saying aye. Aye. All opposed, same sign. That motion carries. Another motion.
I'll move that we bind over Ms. Floyd, Vaughn, Strong, and Dollar to the original office.
All right, we've got a motion to bind over Ms. Floyd, Ms. Vaughn, Ms. Strong, and Ms. Dollar to the Attorney General's office.
Can I ask a question?
Yes, sir.
Did we decide that you have to know whether the person possessed it to mail or possessed it to deliver before we can determine whether there's a violation.
Ms. Simpson, I said that I will be coming to the board at a future meeting with a policy recommendation on that, as well as a disposition to cases that we have received where that is an issue.
But you went through the legislative history and explained it.
I went basically statutory analysis of how the General Assembly chose to phrase that language.
But if you accept that explanation, wouldn't it make a difference as to whether they had it to mail or whether they had it to deliver?
It's my understanding that these questions will be resolved at a future date, and these cases will be consistent with that recommendation.
That is correct.
All right, so we got a motion, do we have a second?
Second.
We've got a motion and a second. Any other discussion? Hearing none. All in favor signify by saying aye. Aye. All opposed, same sign. That motion carries. All right, Ms. Harvey, that's got everybody?
Yes, sir.
All right. Thank y'all for being here today. We appreciate you showing up. Sorry it took us so long on that case. All right, we'll go back to the 2000.
I was going to ask them, why are you all out here today?
We are the soldiers of Christ, and we have the right to vote. It is wrong for others to take our right to vote, because it's very important. It's our constitutional rights.
Will y'all repeat that again for me, please?
We are the soldiers of Christ, and we have the right to vote. And it's wrong for others to take our right to vote, because it's very important. And it's our constitutional right.
Have mercy.
Made mothers to be angels. You just might be looking at an angel right now. If you're in Los Angeles, California, Nashville, Tennessee, Texas, Arkansas, Missouri, Chicago, heaven must be around the corner. I see angels coming down the street. Heaven can't be too far from here. I see angels everywhere. Every mother is an angel. God made it that way. If you look around you, coming down every street in every city, you'll see nothing but angels. In Washington, D.C., South Carolina, or wherever you may be, heaven must be around the corner. I see angels coming down the street. And I look over there, heaven
you doing today?
Very well.
Good. What's your name?
My name's Kevin Moran.
Kevin Moran, where are you from?
I'm from Atlanta, Georgia. I'm a member of Dr. Joseph E. Lowry's Coalition for the People's Agenda. I've been coming down here for the last 4 years, familiarizing myself with this case against these 11 women and 1 man of the very apparent injustice of this matter. This has been orchestrated from the highest levels of this state. The Secretary of State has a vendetta against these upstanding citizens and is trying to suppress the African American vote, not only here in Quitman, Brooks County, but across the entire southern band of counties in Georgia. The women of the Quitman 10 were very successful in using a strategy that the Republican Party has used very successfully, of using the absentee ballot to increase participation in the process. That's what we all want in this democracy, is for participation in the process by informed voters. This has been successfully done repeatedly here in Brooks County. These women didn't win just one election. They didn't win just one primary. They have been reelected and reelected by large majorities in every case similar to the initial election. Today, at the end of the day, on a Friday, here in the courtroom,
Yes, sir.
after being here all week, our attorney, Attorney King, had the opportunity to cross-examine the star witness of the prosecution, Mr. Boone of the United States Post Office. Mr. Boone testified that he had collected the names of and written the names of individuals that mailed in an absentee ballot. This is in violation of his charge and his oath as an officer of the United States Postal Service. I don't want my postman going through my mail and recording who I'm getting mail from. I don't expect my mailman to be recording who I'm sending my Christmas cards to. This is a free country. This is the United States of America. We don't spy on each other in this country. But what he was doing doesn't hold up to the light of day. He presented a list that he swore to of 15 names that he swore put in post office collection box all at the same time. And he swore by one person. Well, very interestingly, upon cross-examination, it was shown in black and white on the return envelope for absentee ballots that one was sent in with a date of July 5th, 2010, and one on a date of July 15th. He had previously testified that every ballot that came in was immediately stamped that day by the local Quitman post office and expeditiously delivered to the registrar of voters here in Brooks County. There were 10 days between the receipt of these two envelopes that he had sworn he recorded on the same day at the same time being deposited by the same person. As the defense attorney said, that is a lie.
It was proven to the jury, the judge, and all in the courtroom. These postmarked return envelopes showed the dates of July 5 and July 10, respectively. Those aren't recorded on the same day. Beyond this, that opened a can of worms that the defense attorney has exposed, that the prosecution does not have. Of those 15 ballots, they have but 2 of the originals. The other 12 are missing. They are unable to produce them. They brought out all the materials they contend that the prosecution has. Put the boxes out, let the defense attorneys go through them. That's all we have, and these documents are not in there. The original documents that he is making these salacious charges on are non-existent. The chief case agent of the GBI testified that she picked up many, many boxes from the election office here in Brooks County.
Ms. Braswell.
That is correct. Ms. Braswell testified. She also testified as an agent of the GBI that she turned over every bit, all of that material to the prosecution. All that's remaining today are what look to me like 3-4 small boxes of some evidence, some pieces of paper. The prosecutor is even admitting that they probably won't be able to find the originals. The judge has ordered them to produce the originals by the convening of court, in this case the next day on Tuesday. It is highly unlikely after all this. They have looked before. They will not find originals. They know they are not producible. Why do originals that are being used to tarnish the reputation and exposed to convictions of innocent people, why does that evidence suddenly totally disappear? And beyond that, the list that the registrar would have of individuals applying for these absentee ballots has disappeared. There is no record that these individuals, who the postal employee claims all mailed in their ballot on the same day, came in the same stack at the identical time, they never show on the records of having received a ballot. The ballots are dated by the post office itself 10 days apart. This is a miscarriage of justice in the state of Georgia that cannot be overlooked. The Secretary of State and the Governor have made it very purposeful that they will send the message that if you are African American, and if you run for office, and if you honestly win the election, you will be punished. The Governor, the Secretary of State are trying to intimidate and suppress the African American vote, since they know if the 400,000 registered African Americans in the state of Georgia that did not vote in the last election cycle come out and exercise a right that people have died for, the right to vote. If the African American community and all people of color exercise their constitutional right to vote, it will mean the demise of this white privileged aristocracy here in Georgia That is not American. That is not worthy of the state of Georgia. This prosecution is a travesty. The prosecutors, the Secretary of State, the governor should be called out on what they have done to these women and called to publicly apologize for the 4 years that they have put them under this scrutiny and this character assassination. So that's how I feel about today.
Thank you very much. This is the Ghetto Free Press, just keeping it real. Once again, I want to appreciate you. You are a prime example, in my most humble opinion. While we cannot hate one another because of the skin color, it's not about skin color. It's about what is right and wrong. I think perhaps that Jesus put it best, and I put it in my own words. Want for your neighbor that which you want, and have for yourself and your own children. Thank you so very much. Thank you.
Amen. Thank you.
Once again, this is the Ghetto Free Press, and I'm George Foster Ryans. And what's your name once again, my beautiful brother?
George, my name is Kevin Moran.
All right. And you're with the People's Agenda.
I'm with the Coalition of the People's Agenda, convened by Dr. Joseph E. Lowry.
All right. I want to ask you a few questions. Number one, I've been here. I missed Monday because I was up there with the newly elected black Mayor Ann Whipperloo, who's being mistreated, and I believe it all interrelated together.
Yes.
But I got here Tuesday, and I didn't see any news media here Tuesday. I didn't see any Wednesday. I didn't see any Thursday, and I didn't see any today. I didn't even see any of the news reporters. I haven't seen anything in the Valdosta Daily Times, a metropolitan city. I only saw a little snippet in the Quitman Free Press yesterday when I got that in my mailbox because I subscribed to the paper. But the question is, how do you think that the news media like CNN, MSNBC, even with Al Sharpton, can ignore or omit what is happening here in Brooks County, where we had hundreds of people to march here because this is a very, very high-profile case. Why do you think that the news media are not concerned about voting rights down here in South Georgia? Apparently because they're not here.
The mass media that you refer to is totally owned and operated by the white aristocracy of Georgia. And it is an inconvenient truth that Quitman 10 plus 12 have been salaciously charged.
10 plus 2.
10 plus 2 with charges for crimes they did not commit, and it was proven today in court.
Okay. Another thing I want to ask you is that if you had not spoken out a little bit about what happened here today, I say that this information that took place in the courtroom outside of the transcript, which will be a matter of record for all eternity, I guess, but without that, the local citizens here in Quitman and Brooks County and all around South Georgia, they wouldn't know anything about it, because when the newspapers are written, which I call the archival record, when they read that in 30, 40 years in the schools require these students to do turn papers on the events of yesterday, they won't be able to retrieve that from the newspaper because it wasn't there.
Yes.
What do you think about that?
I think that's why it is essential that this word get out. And I've been fortunate 4 years ago, when you mentioned hundreds of us gathered here on the steps, to be traveling with an international representative of the Mennonite Church, who I contacted last night that this trial is still going on. He has learned the truth, and he is ashamed that the United States judicial system here in Quitman, Georgia, is lynching these 10 plus 2 for acts they never committed, and by the media intentionally, I really believe it is intentionally not being here.
Yes, sir.
It is an inconvenient truth what has been done here. For 4 years, these women and one man have been subjected to daily harangues, allegations by the GBI, put in jail because they won an election. They won an election to office that had previously been held by white males. And for the first time, we had African Americans of impeccable character and wonderful qualifications as educators elected to the school board. They've been elected 2 times since by the same plurality. This was not a fluke. This was not a manipulated election. This, unfortunately, for some, is the South of the future. Georgia will become a majority state of colored people. Our brothers and sisters in Christ will be represented. This is a democracy in the United States. We have fought for it. We are entitled to our rights of equality under the law. We haven't seen that here, and the media doesn't want to be telling that story because governors, heads of the GBI, secretaries of state will be criticizing them and exerting again power upon them. We're playing with some players that have great power and great audacity to use it. We need to stand up to them. We need to tell the truth. The truth needs to be told. And George, you are telling the truth. You are the only member of the press here today. And it's a privilege to have you here and documenting the truth.
I was going to ask them, why are you all out here today?
We are the soldiers of Christ, and we have the right to vote. It is wrong for others to take our right to vote. It is very important. It's our constitutional rights.
Will y'all repeat that again for me, please?
We are the soldiers of Christ, and we have the right to vote. It is wrong for others to take our right to vote, because it's very important, and it's our constitutional right.
Have mercy.